It's indeed a great honor for the Commission on Administrative Justice to stand here. And first, we start by congratulating our sister commission, the Kenya National Commission on Human Rights. We say the commission is a sister commission because we are born from one womb, Article 59 of the Constitution of Kenya. Congratulations for the boldness. Congratulations for abiding by the Constitution, and you continue to lead in the fight against violation of human rights and for defending human rights in this country. As a sister commission, we take note of that and we take pride that you have been able to do this great work. Congratulations on the launch of the advisory, which is very timely, as has been said by the previous speakers who have spoken ahead of me, taking into consideration what this country has witnessed in the last few years. The recommendations in this advisory, again, are also timely. And the Commission on Administrative Justice reiterates and reaffirms its commitment to promote and defend human rights, including human rights defenders, as mandated by the Constitution, the Commission on Administrative Justice Act, and Access to Information Act. There are various recommendations touching on various government institutions, and as the Office of the Ombudsman, we call on each and every government institution that has been given a particular recommendation to take up those recommendations seriously for purposes of the implementation. The Commission notes recommendation 16 on undertaking of a national survey that is required for purposes of confirming the status of implementation of access to information in Kenya. The Office of the Ombudsman has a dual mandate. The first mandate is on addressing cases of maladministration in the public sector. And the second mandate is on promoting access to information. And we are happy and delighted that our sister commission has noted that there is need for that to be done. We have been doing several researches and work around assessing the level of implementation of access to information. And I'm also glad to note from the survey that you did, it is indicated that over 90% of human rights defenders are able to access information. But like you said, the question is, what do they do with this information when they receive? There has also been reports that indeed there are some government entities that are not releasing information. That's the reason why the Commission on Administrative Justice exists. Kindly forward all those reviews to our commission. Human rights defenders ideally are the best placed on behalf of the Kenyan citizens to invoke our jurisdiction. Whenever you request any information that is held by any government entity, including private sector, and that information is not provided, or is provided in a manner that is not useful, you have a right to approach the commission for a review, and the commission will be able to consider the decision by the institution to decline to provide the information or to provide the information in the manner that is not useful to you as a human rights defender or to the Kenyans that you're defending. And we give binding orders. This is a great opportunity also for human rights defenders because you don't need to go to the High Court straight away to request for orders for release of information. The costs you incur, the time is taken in court. The commission is the first stop where you can bring your request for information. I would like to confirm that since 2016, when the Access to Information Act was promulgated, the Commission has been able to receive over 1,600 review cases on access to information. But again, this is not a lot or enough. I am sure that there are Kenyans who are still struggling, and also from the reports we have received, there are Kenyans who probably are not yet aware that they can come to us, to the Commission, for purposes of request for information. And I'm delighted to report that out of the orders that the Commission has been able to give for information to be released, over 90% of those orders have been complied with by the various government entities that we have ordered to release the information. However, there's still a lot that needs to be done within the sector on to promote the access to information, which is a human rights issue, including the recommendation that Kenya National Commission on Human Rights has given for purposes of us undertaking a national survey. I would like also to report that as part of the work that the Commission is doing, is for the first time we are researching and with a view to develop the first state of openness for this country report. This will be the first probably also within the Africa, and it will give us we will be able to understand where we are at as a nation in terms of openness, which of course is promoted through access to information. Thank you, Commissioner Jedida, for raising the issue of whistleblower protection that is required, because it's very necessary for the human rights defenders. And the Commission on Administrative Justice has been pushing for the establishment of this law and the bill, with a view of ensuring that within the mandate that the Commission has under the access to information, to ensure that there is no reiteration. Any whistleblower should not be affected or discriminated as a result of giving the information that they have given. And putting in place this whistleblower bill will really work towards ensuring that human rights defenders are protected. And we are aware that the bill is at an advanced stage, and we also call on the Office of the Attorney General to really fast track to ensure that this is done. Currently also, the Commission developed the National Access to Information Policy, which is also pending at the cabinet level, and we are also working with the Ministry of ICT to ensure that the policy is adopted. Some of the surveys that we've undertaken have also identified a weakness and the need for government to digitize its information. Because without digitization, it's very difficult to retrieve information that is relevant to human rights defenders as well as our citizens. I have also been requested to give the closing remarks. And as we conclude this launch of the advisory on the situation of human rights defenders in Kenya, I would like to express my deepest gratitude to all of you for your active participation and valuable contributions. This advisory, our sister commission, please note, is a testament to our collective commitment to promoting and protecting human rights in Kenya. Again, I urge all stakeholders, including the government agencies, civil society organizations, and the general public, to note and take actions towards implementation of these recommendations and work together to create a safe and enabling environment for human rights defenders to carry out their crucial work. Oftentimes, the various independent officers and constitutional commissions do give recommendations. And I have also noted that there is one that has been indicated to have been repeatedly been recommended and no action is being undertaken. I believe the time is ripe for the constitutional commissions and independent officers to take further steps to ensure that there is proper implementation framework. And I am aware that under the office of the Deputy President, there are legislative reforms that are going on, and probably this is the ideal time for these CCIOs to strategically place themselves in a situation where to push for legislative reform for purposes of ensuring that recommendations are complied with by government agencies. Again, I reiterate that the Commission on Administrative Justice, also the Office of the Ombudsman, has a mandate to deal with cases of maladministration. Holding a Kenyan citizen or a human rights defender excessively in a police custody, contrary to the law, contrary to the constitution in itself, is a maladministration. And those are some of the issues that we deal with at the Commission. Again, the Commission reaffirms its commitment to enforcing the right to information, and we will take into consideration the recommendations from this advisory to inform our future surveys and research initiatives, ensuring that the voices and the concerns of human rights defenders are reflected in our work. And I believe that this is something we can be able to kickstart CEO as soon as possible jointly to initiate that survey. I now call upon all government institutions mandated to implement these recommendations to do so without any further delay. We urge prompt action to address the challenges faced by human rights defenders and to ensure that their rights are protected. The time for action is now, and we expect tangible progress in the implementation of these recommendations. Together, let's continue to promote a culture of respect for human rights, dignity, and the rule of law. Together, we can build a society where human rights defenders can operate freely and contribute to the advancement of justice, equality, and human dignity for all Kenyans. Thank you once again, and may this advisory serve as a catalyst for meaningful action and positive change in Kenya. Asanteni.